Not long ago, a Canadian entrepreneur sat across from me in Zurich. He had just sold his company, more than $40 million. Clean money, perfectly documented, impeccable reputation. 3 Swiss banks had already rejected him, not because of his wealth, not because of his background, because of one technical detail that almost nobody in Canada talks about. By the end of this video, you will know exactly what it is and how to get around it. Before we begin, every case I describe is fully anonymized. Swiss attorney-client privilege applies without exception. Any resemblance to real persons or events is purely coincidental, and this video is educational only. It is not Canadian tax, legal, or investment advice. Always coordinate Swiss planning with qualified Canadian advisors. So what stopped a $40 million client at the door? Canada is a special case. Securities regulation in Canada is not federal, it is provincial. If a Swiss bank or wealth manager wants to advise a Canadian resident or manage his portfolio, it needs a registration or an exemption filing in the province where that client lives. Ontario is one filing, British Columbia is another, Alberta, Quebec, and so on. An institution that wants to serve Canadians across the whole country needs to cover all 10 provinces separately. Only a handful of Swiss institutions have done that work. For everyone else, a Canadian resident is simply a client they are not allowed to serve. The rejection letter is polite. It says nothing about the real reason. And so wealthy Canadians walk away believing Switzerland does not want them. The opposite is true. Switzerland wants serious Canadian clients, but the door only opens if you knock on the right one. I have seen this pattern for more than 3 decades, first as a banking lawyer and compliance officer inside one of the biggest Swiss banking groups. Later, as CEO of the Swiss Association of Asset Managers, and today in my own boutique law firm in Zurich, where we structure and protect wealth for international entrepreneurs. The Canadian case is one of the most misunderstood in all of Swiss private banking. Let me show you why. Most people put Canada in the same box as the United States. That is a mistake. With American clients, Swiss institutions think about FATCA, SEC exposure, and the notoriously strict U.S. compliance environment. The rules are painful, but they are one set of rules. Canada is different. There is no single national securities regulator. Every province has its own framework. That means a Swiss wealth manager can be excellent for European clients, Middle Eastern clients, Asian clients, and still be legally unable to advise a family in Toronto. The bank may be Swiss. The portfolio may sit in Switzerland. The manager may be fully regulated in Switzerland. None of that automatically makes the relationship compliant on the Canadian side. And here's the part that costs families the most. Nobody checks this early enough. They find a prestigious bank. They find a polished wealth manager. They send documents. And weeks later, the application quietly dies. When I analyze rejected Canadian applications, the same 5 causes come up again and again. First, the institution has an internal policy against Canadian residents. For many compliance departments, the provincial licensing landscape is too complex and the market too small. They simply do not want it. No amount of wealth changes that. Second, the wealth manager is not licensed in the client's province. Pure custody is one thing, but the moment you want investment advice or a discretionary mandate, the provincial registration question becomes serious. This is exactly what happened to the entrepreneur from the beginning. He wanted a managed portfolio. The managers he approached had no filing for his province. Case closed before it ever really opened. Third, the source of wealth documentation is not properly prepared. Canadian entrepreneurs often have complex histories, business exits, real estate, mining, energy, crypto, family companies, and inheritance. All of it can be perfectly legitimate. But the classic question every bank will ask is, how did you make the first million? If the file does not answer that clearly, with documents, the bank sees risk, and risk gets declined. Fourth, the structure is unclear. A trust, a holding company, a foundation, a multi-jurisdictional setup, none of this is a problem in itself. An unexplained structure is. If the bank cannot see in 5 minutes who owns, who controls, and who benefits, the answer is no. Fifth, and this is the biggest one, the client starts with the product instead of the structure. He asks, which Swiss bank should I contact? The right question is completely different. What is the correct Swiss structure for my wealth, my tax situation, my family, and my long-term objectives? Answer that first, and the choice of bank almost makes itself. Let me go back to the entrepreneur with the 3 rejections. We did not send a 4th application. We stopped, and we built the file the way Swiss decision-makers actually read it. We clarified his residency and his Canadian tax status. We defined what he really needed, not a bank account, but discretionary management for the liquid wealth, and a portion of the assets outside the banking system entirely, with physical gold in a private Swiss vault. We documented the company sale, and only then did we approach institutions that hold the filings for his province. The same file that had been rejected 3 times was approved, not because the money changed, because the structure did. A serious Swiss setup for a Canadian family has layers. Legal clarity, who owns, who controls, who benefits. Banking access, an institution that actually fits your nationality, residency, and complexity. Wealth management, a manager who is genuinely permitted to advise clients in your province. Tax coordination, Switzerland is not a hiding place. Those days are over. A modern Swiss structure is transparent, reportable where required, and coordinated with your Canadian advisors. And for many families, one more layer, physical gold, stored in private Swiss vaults outside the banking system. A securities portfolio, however well managed, still depends on banks, brokers, and market infrastructure. Gold does not. It answers a different risk, currency risk, banking risk, political risk. But even gold must be purchased, stored, and documented correctly, or the protection becomes a tax problem. One warning, because I see it constantly. If anyone promises you secrecy, shortcuts, or no reporting, walk away. That is not Swiss private banking. It's a red flag. That is a risk of total loss with a nice view of the Alps. If you are a Canadian entrepreneur, investor, or wealthy family, here is the sequence that works. Define the objective first. Diversification, asset protection, wealth management, estate planning, gold storage, or a combination. Then prepare the source of wealth documentation before anyone asks for it. Clarify your Canadian status, resident, leaving Canada, or citizen abroad. Each one changes the analysis. Identify the institutions that hold a license in your province, because most do not. And approach one right door with a clean file, instead of 5 random doors with a messy one. A rejected application is not neutral. It leaves traces, and it makes the next application harder. So, can Canadians open Swiss bank accounts? Yes, but not with every bank, not with every wealth manager, not with every structure, and never without preparation. The entrepreneur from the beginning of this video banks in Switzerland today. Part of his wealth is professionally managed in his province-compliant mandate. Part of it sits in a private vault in physical gold outside the banking system. What changed was not his money. What changed was that someone built the structure before touching the door handle. At Caputo & Partners in Zurich, we do exactly this for international clients. Swiss banking access, wealth management, legal structuring, asset protection, and physical gold storage. If you are Canadian and you want to explore Switzerland the right way, contact us for a confidential legal consultation. The link is in the description. Your assets deserve more than hope. They deserve a fortress.